everyone. I'm Parissa, or for those who know me already, Paris. And I'm going to be speaking about Section 204, homelessness appeals. The focus of the talk I've put together today is on suitability rather than the breadth of the homelessness appeals, largely because I have 20 minutes and not your entire day. So if we were going to even start to delve into things like intentionality, well, I worry I'd put a lot of you to sleep. And first of all, looking at when these appeals arise and how they arise, the approach of the courts to the appeals, then a bit of a focus into suitability and really how to weigh all of that up in terms of whether you're on either side of the fence for landlord or tenant, the sort of matters that should be taken into account and how best to either bring a challenge or protect yourself from such challenges. So what is a Section 204 appeal? These are appeals in the county court, and effectively they're a reconsideration by that court of adverse decisions made by local authorities in homelessness matters. The key here is to remember that they're appeals on a point of law, not on the facts of a case. Really, these tend to come up where we have applicants who are not satisfied with decisions of the local authority, or where they don't receive decisions in the appropriate time. They arise as a result of the duty under the Housing Act, and I've set out Section 193 in your handouts, as well as the various events under Section 193(5) to paragraph 7AA that can bring that homelessness duty to an end. Moving then to focus on suitability. Suitability is addressed specifically in Section 193, and I've set out the specific reference there. The top and bottom of it is that a local authority should not make an offer of housing unless they're satisfied that accommodation is suitable for the applicant. If it's not suitable, then by virtue of Section 206, paragraph 1B, that main housing duty isn't brought to an end. I've focused on suitability because I've seen quite a lot of these cases coming through, acting both for landlords and tenants, where tenants are saying that the house that they've been allocated, the flat, the property, just simply isn't suitable based on the application they've made to meet their needs. So moving then to the internal review stage, because when decisions are made, of course, the local authority or the applicant rather, can seek an internal review. And the review decision letter is the starting point for all of these appeals. So in terms of those who are here and act on behalf of landlords and local authorities, really what must be at the forefront of your mind is whether any of the decision as it is in the decision review letter can be shown to have something lacking, because that's what any appeal would be looking at. So really what that means is, were there any significant issues that either A, were not addressed, or B, were addressed inadequately, and could that have led to any unfairness? Now paragraph 19.21 of the Homelessness Code really provides a blueprint of the sort of matters, particularly for those who act on behalf of tenants, to take into account when they're looking at these decisions to see whether there might be a form of challenge. I have also included, as you can see, reference to a couple of cases, and those are interesting cases because what they confirm is that, in fact, authorities must be able to show that they've followed their own internal policies. So really, anybody acting on behalf of a tenant should be seeking copies of those policies to be disclosed and making sure that they have copies of those so that they can measure up what's being put in any review letter against those policies. And really that should also be at the forefront of the minds of any landlords completing these reviews. Now, in terms of what the Section 204 appeals consider and the approach of the courts, I've put it in big bold letters because I've seen that this isn't always the approach that's taken in these challenges when challenges are brought. They consider points of law and not the facts of the case. And in fact, really, they're more akin to judicial review proceedings, and that was established by the authority that's on the stage, Nepean and Bigham and Tower Hamlets Borough Council. What that means is that the court's considerations are limited to whether or not the decision was lawful, and what follows from that is that their powers, like in a judicial review, are simply to confirm, quash or vary decisions. What the court isn't going to do, or certainly shouldn't do, and would likely be appealed if they did, is make its own findings of fact. So you're not going to get a court finding that your appellant should live in X district of whichever council area. That's not the sort of thing the court would be looking at. Instead, you might get a decision that indicates that, because it might state that factors haven't been considered, and if they had, it might have led to a different decision, but you're not going to get the court intervening in that sort of way. In terms of the burden of proof in these cases, that is very much on the appellant, and the deference is to the public decision making. I've included a really key quote from the R and Hillingdon London Borough Council ex parte Pulhofer case, which effectively says that exactly that the court will defer to the decision-making power of public bodies unless they can be shown to be acting perversely. So really, for those who represent tenants, the focus should be on demonstrating that they are acting perversely. This isn't simply a case of stating that you don't agree with the decision. It's how they made the decision and the mechanics of that any challenge really needs to focus upon. And to reiterate the point, as I've set out in the handout, what that doesn't mean is that a reviewing officer, whether it's in drafting their review decision letter or in responding to a challenge brought via appeal, they don't have any burden to positively show that they've correctly understood the law or in fact addressed every single point raised by an applicant. That the burden, as I've stated, rests squarely upon the person who is bringing the challenge. And to that end, you'll see that I've also included a paragraph from the decision in South Bucks DC and Porter number 2 from 2004. It sets out very clearly there that decision letters are to be read in a straightforward manner, recognising that they are addressed to parties well aware of the issues involved and the arguments advanced. In short, what that decision provides authority for is a position where decision letters do not need to raise every single argument that an appellant may have brought in making their application. They need to simply recognise an awareness and consideration of those arguments. So there's no need to recite every single piece of evidence, for example. You're going to end up, if you do, with decision letters or review decision letters that are 40 pages long or more. The fact of the matter is that if the decision letter does deal with each of the broad issues and refer generally to the evidence that's raised, that's likely to be found by the courts to be enough. And I have recently been involved in a case where a challenge was brought really on exactly that basis. There was reference throughout it. The case involved a claim where it was suggested that on the basis of medical needs, the property that had been allocated to this individual simply wasn't suitable. She needed to be closer to family and friends. And I've seen a lot of that sort of argument coming up quite frequently. In this case, the challenge was brought really on the basis that one of the primary arguments was that there were several pieces of medical evidence from people involved with mental health services, GPs, consultants, more than one letter, in fact, from the GP. In the decision letter, rather than refer individually to each, the letter dated X, the letter dated Y, etc., they referred more collectively to the medical evidence and referred specifically only to one of the letters. That challenge just wasn't entertained by the court. I was representing on that occasion the local authority, took the court to these cases, and the court agreed quite simply that it was very clear that all factors had been considered, and simply because each and every letter wasn't mentioned in the review decision, that wasn't going to be enough to mean that the decision was perverse. The argument was taken further in stating that actually, even if they'd considered them specifically, it wouldn't have changed the decision overall. as I've set out, the review decision letter is really the starting point in these cases. And I've cited yet more case law there, which effectively, if I can summarise it, and it is set out in full in your handout, really warns against an overzealous linguistic analysis and advises that courts should be taking what's termed a benevolent approach when they look at interpreting these review decision letters. Again, they're not going to look for every single piece of evidence to be cited. They're going to take a broader look at what the decision considered. That's not to dishearten those of you who do act for appellants in these cases, because although the court doesn't want nitpicking over what's exactly the wording of the letter, there are still a number of factors that are brought to bear and not dealt with fully in a lot of these local authority letters I've seen. So I'm going to move on to talk about suitability, and there are multiple factors to be considered in terms of suitability. Location is, of course, a key one, and as I've said, I'm seeing this come up more and more in terms of being interlinked with medical needs in the way that it's brought as a challenge, effectively saying I need to stay in X area because I need to be close to my GP, my consultant, my mental health support service, my family who provide me with support. If it can be demonstrated that regard has not been had to evidence that's being put before the local authority, or indeed that, for instance, the local authority has said, well, yes, we got that letter from your consultant and the one from your GP and your mental health counsellor, but actually we don't think that matters, and disregarded it, which is something I have seen, believe it or not, there's still going to be room for challenge. And on that note, I have included some of the detailed guidance set out in Charlotte and Birmingham, a 2007 decision, around the use of medical advisors in local authorities and how they can be brought to bear in these cases. In short, and on the basis of the recommendations in that decision, I would suggest that caution is exercised by local authorities when assessing the validity of medical evidence. Although it's a local authority's prerogative to attach weight to medical evidence and weight in amongst other various factors, the likelihood is that the majority of those people making those decisions don't have the medical or other expertise needed to disregard evidence when it's put in. If you have a letter from a GP saying there's a serious issue for one of their patients, unless you've got something to directly challenge that from another medical professional, I would suggest that you stay well away from doing so. It would be a very easy challenge to bring. I'm going to briefly mention the public sector equality duty. It is again in your handout. In short, it does apply in those cases. And interestingly, in the decision in Hortack and Southwark, Lord Neuberger, who was advocating the benevolent approach in the earlier case of Holmes, goes back to really mediate what he said and says that although he still suggests that a benevolent approach is taken to local authority review decisions, they must now be read in light of the contents of paragraph 78 of the decision above, where equality duty is engaged. In other words, yes, local authority might be given a measure of discretion in terms of these letters, but they must consider the PSED. Again, you'll note, and I've included cases, Hackney LBC and Canaan to this end, that not each and every one of those considerations I've set out in the handout needs to be explicitly dealt with. It's a general recognition of the severe effects of the disability or other protected characteristic upon the individual applicant that actually the court would need to see before it was able to uphold the decision. Now, the case law does, and again it's referred to in your handout, specifically deal with and acknowledge the fact that local authorities' housing stock is hard-pressed. There's not enough houses for the number of applicants, arguments that we're well familiar with. But what I often see is that local authorities aren't including these specific arguments in their review letters. And this is a point to be taken really whether you're a landlord or a tenant representative. on the part of the landlords, if there are factors that have been brought to bear that mean that in spite of, for example, medical evidence, you've taken a course of action, you need, in my view, to explicitly state those factors, because whilst there is case law that suggests, and we all know fine well, that the demand outstrips the supply in terms of housing stock, often the specific factors that are at play in your specific local authority may well not be as well known. In my view, assuming that they're well known to the court is a dangerous game to play, and also leaves a position where you might have chosen a course of action, but if you've recognised, for example, a person has a significant medical need, but not set out in detail why you've chosen not to give that priority, you're leaving yourself open to challenge. And so in terms of tenant representatives, I would suggest that that's something to look at and a possible avenue to explore if you're looking to bring challenges.